Hi, welcome again to the Basic Filipino and Jurisprudence channel. So, we will begin with the family code of the Philippines. Let us start with marriage. What is marriage? Marriage is a special contract of permanent union between a man and a woman entered in accordance with law for the establishment of conjugal and family rights. So there are actually two aspects of marriage. First, it is a special contract. What makes it special? It is special because it is governed by law and it cannot be subjected to the stipulations between the parties except, of course, with respect to property relations. So that is the only aspect of marriage that can be stipulated upon by the parties before they enter into marriage. So, for example, you cannot uh, fix the term of the marriage. As you all know, marriage is a special contract. So, until it is annulled or declared a nullity by a competent court or one of the parties die, then it subsists. Okay? It cannot be subjected to a fixed term or it cannot be terminated at the mere whim of the parties. The second aspect of marriage is it is a status or a relation or an institution. Okay, so it fixes the civil status of a person and it is also an institution on which the state takes an active interest on. Okay, because it is the basic foundation of the family. So the state has a special interest with respect to marriage as an institution. Let us now go to the first case, Tilar versus Tilar. So in this case, this is actually a petition for declaration of nullity of marriage under Article 36 of the Family Code. Now, it was dismissed by the trial court, by the regional trial court, on the ground that allegedly the trial court has no jurisdiction because it is a marriage which is solemnized before the rites of the Catholic Church. So it is the contention of the judge that considering that it is solemnized under the rites of the Catholic Church, the trial court has no authority to invalidate the said marriage. So the party should go to the Catholic Church so that the Catholic Church, under the canon law, can invalidate or declare their marriage a nullity. Now, is it correct? Meaning, is the trial court correct? In the case of Pilar, the court again defined marriage as a special contract. Uh, and the family code provides for essential as well as formal requisites for their validity. Now, is the trial court correct? The Supreme Court said in this case, the contract of marriage is entered into by complying with the requirements and formalities prescribed by law. The marriage of the parties, which was solemnized by a Catholic priest, although held in church, was in accordance with the family code. Although marriage is considered as a sacrament in the Catholic Church, it has civil and legal consequences, which are governed by the family code. The declaration of nullity of the parties' marriage in the religious and ecclesiastical aspect is another matter. The proceedings for church annulment, which is in accordance with the norms of canon law, is not binding upon the state as the couple is still considered married to each other in the eyes of civil law. So in other words, the important thing to remember in Tilar versus Tilar is that marriage is governed by law. When we say law, it is specifically it is the family code of the Philippines. If the marriage is celebrated after its effectivity in 1988. So regardless of the religion under which the rites of the marriage were solemnized, if it is governed by law, and therefore if you are filing for an annulment or a declaration of its nullity, the trial courts are equipped with jurisdiction to declare the same as a nullity or to annul the marriage. Okay. Now, what are the essential and formal requisites of marriage? Remember, the presence of all these essential and formal requisites is required for the validity of a marriage. If any of these essential or formal requisites are not present, meaning they are absent, or there is a defect or irregularity in either the essential or formal requisites, it will have a corresponding effect on the marriage. There is an absence, it will make the marriage void. If there is a defect, it would make the marriage voidable. If it is an irregularity, it will subject the person responsible for the corresponding disciplinary sanctions. Now, Article 2 gives us the essential requisites of marriage. What are these essential requisites for the validity of a marriage? First, it is the legal capacity of the contracting parties who must be a male and a Okay, there are actually three uh, requirements, okay, for a person to be capacitated to marry. First is the age. In the Philippines, you must be 18 years of age or older. Okay. Second is gender. Okay, the marriage must be between male and female. As of the moment, there is no same gender marriages. Although in some other countries, they may be considered as valid, in the Philippines, it is not because it is part of the requirement for legal capacity. The third one is relationship. Okay, you cannot marry your ascendant or your descendant of any degree. You cannot marry your first cousin because you are related to her by within the fourth degree. You cannot also marry your siblings, whether it is full or half blood. So in other words, relationship is a relative requirement for legal capacity. Okay, so again, in legal capacity, there are three factors to be considered: the age, the relationship, as well as the gender. Okay, the second requirement, essential requirement for the validity of a marriage, is consent, freely given in the presence of the solemnizing officer. The consent must be free, otherwise the marriage becomes void. Okay, so when I say free, it means that you are not under force, you are not under duress. Okay, it is voluntarily given. Okay, it is of your own volition. And it must be given in the presence of the solemnizing officer. Okay, if you have given your consent to the marriage in the presence of your would-be spouse only, without the solemnizing officer, then that would not be considered as also a valid consent, because there is a requirement that the solemnizing officer must likewise be present, and it is the solemnizing officer who will witness your consent to the marriage, aside from the two witnesses of the marriage. So again, the essential requisites for a valid marriage are legal capacity as well as the consent freely given in the presence of the solemnizing officer. Okay, now Article 3 gives us the formal requisites for a valid marriage. What are they? First, it is the authority of the solemnizing officer. You must remember that in marriages in the Philippines, the contracting parties cannot just marry themselves. Okay, it must always be before the solemnizing officer who is authorized by law solemnize marriage. So if the solemnizing officer is not authorized by law, it will have a corresponding effect. Okay, it may be an irregularity if the parties believe that he had the authority to do so, but he is really not in fact authorized by law. Okay, you will see that later when we go to the succeeding chapters. Okay, the second is a valid marriage license, except of course in cases in which are considered the exception. Okay, so you must have a valid marriage license. You must know that a marriage license is actually the consent of the state to the marriage. Okay, so um, it is not only the parties who are giving their consent to the marriage, the consent of the state in the presence of a valid marriage license is also required. When I say valid marriage license, it means that it is still not expired. Okay, because a marriage license has a validity of 120 calendar days. So within that 120 calendar days, you must get married. Otherwise, if that period has already lapsed, the license is no longer valid. So it is as if you have no marriage license. Okay. Third is a marriage ceremony, which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than two witnesses of legal age. Okay, so it is required as a formal requirement to the marriage that there must be a marriage ceremony. Okay, it is not sufficient that the parties just appear before the solemnizing officer without a marriage ceremony. Okay, there must be a personal declaration that they take each other as husband and wife, and in the presence of at least two witnesses of legal age. Okay, now what is the effect again of the absence, defect, or irregularity of the essential or the formal requisites of a marriage? So the absence, as I've said before, if any of the essential or formal requisites are absent, it will render the marriage void ab initio. Okay? How about a defect? What is the effect of a defect in the essential requisites? It shall render the marriage voidable. Okay? So, again, what are the essential requisites? First is legal capacity. Second is consent. So, the classic example of a defect in the essential requisite is if there was a defect in the consent. Okay, like for example, if the consent was under duress, okay, there was force or intimidation in the giving of the consent. So it may be said that there was a defect in consent. Why? Because it is not free. Okay, so what will be the effect? It will render the marriage voidable. So when you say voidable, it is not void ab initio. It is valid until until. Okay. Now, how about irregularity in the formal requisite? Okay. An irregularity in the formal requisite shall not affect the validity of the marriage, but the parties responsible for the irregularity shall be civilly, criminally, and administratively liable. So whoever is responsible for the irregularity can be held civilly, criminally, or administratively liable. Okay. Now let us go to Article 5. Article 5 refers to legal capacity and consent. As I have said a while ago, legal capacity refers to the gender, age, or relationship. Okay. Article 5 tells us that any male or female of the age of 18 or upwards, not under any of the impediments mentioned in Articles 37 and 38 may contract marriage. 37 refers to incestuous marriages. So it refers to relationship. 38 refers to void marriages by reason of public funds. They also refer to relationships. So Article 5 tells us of the legal impediments to the marriage. So if you are a minor, if you are of the same gender, or if you are related by blood to the spouse, to your would-be spouse, then it would affect your legal capacity to contract marriage. Okay. Article 6 tells us that there is no prescribed form or religious rite for the solemnization of the marriage. It is necessary, however, for the contracting parties to appear personally before the solemnizing officer and declare in the presence of not less than two witnesses of legal age that they take each other as husband and wife. There is no necessity for the recital or exchange of vows that you are going to live together for better or for worse, etc., etc. What is only needed is a declaration that you take each other as husband and wife. That is all. Okay. Now, is a ceremony required? Article 6 tells us there is no need for a ceremony. But there is no particular form of ceremony that is required. A marriage ceremony is required, but there is no particular form. There is no need that there should be sponsors for candle, veil, ring. Okay? What is only required is that you declare in the presence of the solemnizing officer as well as two witnesses of legal age that you are taking each other as husband. Okay, is there a marriage by proxy? Okay, a marriage by proxy is void because it requires the physical presence of the parties. There is also a question which cropped up in class regarding marriage through online marriages. My personal opinion or take on that matter is that it is a mere irregularity. Why? Because although personal appearance is required, considering the situation at that time when we were facing a pandemic, okay, it is a mere irregularity because the parties are present online, although not physically. So it is only an irregularity in one of the formal requisites of a marriage, which is the ceremony. Okay. We go to the case of Morimoto versus Morimoto. Okay. In this case, the court defined a simulated marriage, which is used as a front for illicitly obtaining benefits, is totally inexistent, as the parties to it have no genuine intent to enter into marital relations. Courts must recognize such marriages as void. To insist on its validity is to enable a greater affront to the institution of marriage. Okay, this is a case in which the parties, in order to facilitate the Japanese visa of the petitioner, entered into a simulated marriage with a Japanese. Okay, they signed a blank marriage certificate, but they were assured that it will never be registered. However, to the surprise of the petitioner, when she was securing a senomar, she was surprised to find out that the said marriage was indeed registered. However, it was the contention of the petition that the marriage did not actually happen because there was no marriage license. So there was an absence of one of the formal requisites of the marriage. Now, the issue in this case is whether or not the registered marriage between the petitioner and the respondent should be declared null and void. Okay. Now, the Supreme Court said that when there is no bona fide intention of becoming a spouse to another, a marriage is void for want of consent, even when marriage ceremonies have been conducted and there the parties declared their intent to enter into married life. The court finds the petitioner's declaration of having participated in a duplicitous design to be worthy of even greater credence as an admission against interest. So ultimately, the registered marriage between the petitioner and the respondent is fictitious and inexistent, thereby warranting a declaration of none. Equally fatal to the marriage is how no marriage license was ever issued to them. Later, we will compare this case to the case of Republic versus Albios. Remember, in Morimoto, there was a lack of marriage license. So one of the formal requisites of marriage is totally absent, which is a valid marriage license. Okay, Palstis versus Civil Registrar General. Okay. What is important in Palstis is the requirement of gender. Okay, because in this case, what is being sought to be declared as unconstitutional is the provision of the family code regarding the requirement that marriage should be between man and a woman. According to the petitioner in this case, it is violative of their right, okay, to the equal protection clause, because the petitioner in this case is a member of the LGBTQIA plus community. So according to him, it is his contention that same gender marriages should likewise be accorded protection and should likewise be recognized as a valid marriage under the family code. Okay, so he wanted Articles 1 and 2 of the Family Code to be declared as unconstitutional. So the issue in this case is whether or not denying same-sex couples the right to marry amounts to a denial of their right to life and or liberty without due process of law. Okay, how did the Supreme Court resolve? The Constitution does not define or restrict marriage on the basis of sex, gender, sexual orientation, or gender identity or expression. The Constitution should be read in a holistic approach. As a legally binding relationship that unites two individuals, marriage becomes an enabling constraint that imposes certain duties on married couples and even limitations on their action. Articles 1 and 2 of the Family Code provides a definition that serves as a foundation of many other gendered provisions of the Family Code and other laws. So you must remember that it is not only the Family Code, okay, which provided for a definition of marriage and the requirement that it must be between man and a woman. Now, there are other laws also which took upon this definition of the family code. So when you invalidate and struck down Articles 1 and 2 of the family code, it will have a ripple effect on other laws. So therefore, the declaration of unconstitutionality of Articles 1 and 2 of the family code is not an end or a solution to the problem or to the issue posed by the petitioner. So it is the position of the Supreme Court to Exponente, Senior Associate Justice Yonen, that the remedy lies not within the court. The remedy lies within the Congress or within our legislature. Okay? The task of devising an arrangement where same-sex relations will earn state recognition is better left to Congress in order that it may thresh out the many issues that may arise. Okay? Now we have another case, Perfecto versus Esidera. So this involves a judge. This is an administrative case. Okay, she was first married to Richard in 1987, okay, at the Metsi, Manila. So it was a civil wedding. Okay, now her marriage to Richard was later declared void in 1992. Okay, now in the interim, Esidera married or entered into a religious marriage with another man. Okay, but the priest who officiated their wedding had no authority to solemnize their marriage under the civil law. You must remember that authority of the solemnizing officer is one of the formal requisites of a marriage. So if that is absent, what would happen? Okay, if one of the formal requisites is absent, the effect would be the marriage would not be valid, it would be void ab initio. According to Esidera, okay, what she did was legal and in accordance with her religious beliefs. She was indeed married to her second husband at the time when her first marriage was still subsisting, but only under Catholic rites, because the priests who officiated their wedding had no authority to solemnize marriages under the civil law. Okay. Religious marriages are recognized in and may be governed by our laws only if they conform to legal requirements. So the lack of authority of the officer that solemnized the respondent's marriage renders such marriage invalid. Okay. However, it did not exempt Isidera from disciplinary authority because according to the Supreme Court, benevolent neutrality and claims of religious freedom cannot shield the judge from liability for misconduct because she knowingly entered into a civil marriage with her first husband. She knew its effects under our laws and she had sexual relationship with her second husband while her first marriage still subsists. Okay? Okay, we now come to Republic versus Albios. As I have said, we will discuss this in relation also to the previous case of Morimoto versus Morimoto. So in this case, Springer is an American citizen. He married Albios. They were married in civil rights. Now, after a few years, Albios filed a petition for declaration of nullity of the said marriage. She alleged that immediately after their marriage, they separated and never lived as husband and wife because their intention was really to for Albios to acquire American citizenship. So according to Albios, the marriage was only in jest. Okay. Now, according to the petitioner, consent as an essential requisite of marriage is not present because their only purpose is to acquire American citizenship. Now, the issue in this case is a marriage contracted for the sole purpose of acquiring American citizenship void ab initio on the ground of lack of consent. Okay. As you all know, consent is an essential requisite of marriage, and the consent must be freely given. As such, it must not be vitiated or be affected or rendered defective by the vices of consent. Was there genuine consent in the marriage when it was only for the purpose of acquiring American citizenship? According to the High Court, consent was not lacking between Albios and Fringer. In fact, there was real consent because it was not vitiated nor rendered defective by any vice of consent. Their consent was also conscious and intelligent as they understood the nature and the beneficial and inconvenient consequences of their marriage. That their consent was freely given is best evidenced by their conscious purpose of acquiring American citizenship through marriage. Such plainly demonstrates that they willingly and deliberately contracted the marriage. There was clear intention to enter into a real and valid marriage so as to fully comply with the requirements of an application for citizenship. So if you compare this with Morimoto, Morimoto, the absent requirement there is the formal requisite of a valid marriage license. In this case, in Albios, the issue here is the essential requisite of consent. So it was the contention of Albios that the consent was not freely given. Okay, because their only purpose is to acquire American citizenship. But according to the court, no. Okay, the consent was freely given. You know that you are entering into a marriage because of that American citizenship. So the law does not concern, the law is not concerned with the purpose or motivation for which you gave your consent to the marriage. What is important is you know that you are entering into a marriage. Okay? Also, in this case, the Supreme Court defined what is a marriage in jest. It is a pretended marriage, legal in form, but entered into as a joke with no real intention of entering into marriage, and with clear understanding that the parties would not be bound. It is a pretended marriage not intended to be real and with no intention to create any legal ties. So in this case, the parties had an undeniable intention to be bound in order to create the very bond which is needed to allow her to acquire American citizenship. There is no law that declares a marriage void if it is entered into for purposes other than what the Constitution or the law declares, such as the acquisition of foreign citizenship. Therefore, as long as the essential and formal requisites are present, it is not void. Remember that the Constitution, the Family Code, in the definition of marriage states that for the purpose of establishment of conjugal or family. That is not part of the essential nor the formal requisites of marriage. So regardless of the intention, okay, or motivation for which you entered into a marriage, it is not important. What is important is that you know that you're entering into a marriage, okay, and that you gave your genuine consent there uh, without being under duress or under any force or threat. Okay, so in other words, the biases or the defect of consent are not present. Okay, motives for entering into a marriage are varied and complex. Okay, the right to marital privacy allows married couples to structure their marriage in almost any way that they see. Marriages entered into for other purposes such as convenience, companionship, money, status, and title, provided that they comply with all the legal requisites, are equally valid. Love, although the ideal configuration, is not the only valid cause for marriage. Other considerations not precluded by law may validly support the marriage. Okay? We now go to the case of Abbas versus Abbas. Again, this um, concerns marriage license, one of formal requisites of a valid marriage. So in this case, the petitioner filed the complaint for declaration of marriage on the ground that there was no valid marriage license. Okay, the petitioner testified that he did not go to Camona to apply for a marriage license because he never resided in that area. There was a certification to the effect that the marriage license appearing in the marriage contract is the number of another marriage license issued to another couple. So, in this case, the Supreme Court held that um, the registrar of Carmona, where the marriage license of the parties was issued a certification that there was indeed no such marriage license and that it was issued to another couple. So it is also noted that the solemnizing officer testified that the marriage contract and a copy of the marriage license were issued to the LCR of Manila. Thus, a copy of the marriage license could have simply been secured from that office and submitted to the court. However, Gloria failed to do so, further weakening her claim that there was a valid license issued to her and the petition. Okay, so if your ground for seeking a declaration of nullity is the absence of a marriage license, then you should present a certification from the concerned local civil register that there was indeed no such marriage license that was issued or that it was issued to another couple. Okay? The case of Oka versus Permis. Okay? This is regarding the irregularity in one of the formal requisites. Okay, remember that authority of the solemnizing officer. Okay, the authority of the solemnizing officer is one of the formal requisites of a marriage. So the act of solemnizing marriages without the required marriage license constitutes misconduct. So before a solemnizing officer performs a marriage ceremony, it is his duty to personally interview the contracting parties and examine the requirements that they submitted. If they have already complied with all the essential and formal requisites of marriage. So the judge must personally examine the affidavit of cohabitation as to the parties having lived together as husband and wife for at least 5 years. The judge must also execute a sworn statement that he personally ascertained the parties' qualifications and found no legal impediment to the marriage. Marriage in this country is an institution in which the community is deeply interested. The state has surrounded it with safeguards to maintain its purity, continuity, and permanence. The security and stability of the state are largely dependent upon it. It is the interest and duty of each and every member of the community to prevent the bringing about of a condition that would shake its foundation and ultimately to its destruction. Okay, we have the case of Navarro versus Domagtoy. Um, this is the case wherein the judge performed the marriage outside of his jurisdiction. Would that constitute absence of authority of the solemnizing officer, or would it be merely an irregularity that would hold the person responsible for it administratively or civilly? So in this case, the judge performed the marriage ceremony in a place which is outside of his jurisdiction because he is a judge of the Municipal Circuit Trial Court of Santa Monica, Burgos, Surigao del Norte. So the wedding was held in the judge's residence in Dapa, which is not within his area of jurisdiction. Okay. Article 8 of the Family Code refers only to the venue of the marriage ceremony and does not alter or qualify the authority of the solemnizing officer. Non-compliance therewith will not invalidate the marriage. So the mere fact that the judge solemnizes it outside of the area of his jurisdiction does not affect the validity of the marriage. It is a mere irregularity in one of the formal requisites, which will render the judge liable administratively. Judges who are appointed to specific jurisdictions may officiate in weddings only within the said areas and not beyond. When a judge solemnizes a marriage outside this jurisdiction, there is an irregularity in the formal requisite, which it will, while it may not affect the validity of the marriage, may subject the officiating official to administrative liability. Okay. Coopers versus Murcia is a related case, which is almost on all fours with Navarro versus Domagtoy. So in this case, also a municipal trial court judge again solemnized a marriage outside of his jurisdiction. Okay, because he is again a municipal trial court judge in the island garden city of Samal. Now, he solemnized the marriage in Davao City, which is outside his area of jurisdiction. So again, it only rendered an irregularity in one of the formal requisites, but it did not affect the validity of the marriage. Okay. Now, Article 7 tells us the persons who are authorized to solemnize marriages. Now, who are these people? Okay, first, any incumbent member of the judiciary within the court's jurisdiction. So when I am emphasizing on the word incumbent, so meaning it must be a judge which is still in the service. So meaning if a judge has already retired, then he loses his authority to solemnize marriage. Okay. Second, any priest, rabbi, imam, or minister of any church or religious sect duly authorized by his church or religious sect and registered with the Civil Register General, acting within the limits of the written authority granted him by his church or religious sect, and provided that at least one of the contracting parties belongs to the solemnizing officer's church or religious sect. Okay? So, with respect to religious authorities, what is important is that that person, in order to be considered as a person authorized to solemnize marriage, must be given authority by his church or religious sect and is registered with the PSA or the Civil Registrar General. And at least one of the contracting parties is a member of the church or religious sect. A third, any ship captain or airplane chief only in the cases of marriages in articulo mortis. Any military commander of a unit to which a chaplain is assigned in the absence of the latter during a military operation, likewise only in cases of in articulo mortis marriages, and any consul general, consul, or vice consul in cases of marriages between Filipino citizens abroad. Okay? And under the local government code, mayors and governors. Okay? They have the authority to solemnize marriages within their jurisdiction. So you must remember that with respect to ship captains, airplane chief, military commander of a unit, their authority to solemnize marriages is limited only to in articulo mortis marriages or marriages in the point of death. Okay? So it is only in these cases when they are authorized to perform marriages. Marriages in um, regular, shall I say, ordinary circumstances wherein the parties are not at the point of death, okay? These people, ship captains, airplane chief, military commander, are bereft of any authority to solemnize said marriages. Also, with respect to consul generals, consul or vice consul, they also have limited authority in the sense that they can only solemnize marriages between Filipino citizens abroad. Okay? So, if for example, a consul in Spain can only solemnize marriages between Filipino citizens in the consular in Spain. Okay? Uh, with respect to uh, religious officials, it depends on the authority that is given to them by their church. With respect to incumbent members of the judiciary, their authority is limited to their respective areas of jurisdiction. The same is true with respect to mayors or governors. Their authority is limited to the areas within their jurisdiction. Question, are Supreme Court justices authorized to solemnize marriages? Yes, and their authority is national. Okay. Public solemnization. Article 8 tells us the marriage shall be solemnized publicly in the chambers of the judge or in open court, in the church, chapel, or temple, or in the office of the consul general, consul, or vice consul, except in marriages in articulo mortis or in remote places. or where both of the parties request the solemnizing officer in writing, in which case the marriage may be solemnized at a house or place designated by them. Okay, there are cases or instances when the parties can request in writing the judge or the religious official to solemnize their marriage at another place, at a place other than the court, other than the church. Okay? But they must request for it beforehand in writing. Okay? What is the reason? Why is it that there is a requirement for public solemnization? Again, the state takes an active interest in the marriage, and there is a requirement that it must be done publicly so that the solemnizing officer will be able to know if there are impediments to the marriage. So it must be done publicly so that any person who is so minded can tell or inform the solemnizing officer before the marriage of any impediment of uh, any or both of the parties. Okay. We have the case of Ronolo versus People, okay, regarding the formal requirement of marriage ceremony. You will recall, okay, there is no prescribed form of ceremony that is required in order for a marriage to be valid. What is only required is that you declare in the presence of the solemnizing officer or and at least two witnesses of legal age that you take each other as husband and wife. So in this case, what happened is that they had difficulty in securing a valid marriage license. So they requested an Aglipayan priest to perform a ceremony. Okay, now the Aglipayan priest, because the reception is already booked and the uh, parties are already in their wedding dress, okay, that is the reason why they went to an Aglipayan priest and requested him to perform a ceremony. Now, the Aglipayan priest was charged for violation. Article 352 of the Penal Code for performing an illegal marriage ceremony. Now, the petitioner admitted that he conducted a ceremony, but it was not uh, a solemnization of marriage as contemplated by law, because what he did only is a blessing. So he merely blessed the couple. Now the issue is whether the alleged blessing is tantamount to the performance of an illegal marriage ceremony. So the Supreme Court said in the case of Romulo, Article 3 mirrors Article 6 of the Family Code and particularly defines a marriage ceremony as that which takes place with the appearance of the contracting parties before the solemnizing officer in their personal declaration that they take each other as husband and wife in the presence of not less than two witnesses of equal age. So the law sets the minimum requirements constituting a marriage ceremony. What is the first requirement? There should be personal appearance of the contracting parties before a solemnizing officer. The second requirement, their declaration in the presence of not less than two witnesses that they take each other as husband and wife. So indeed, in this case, there has been a declaration that they take each other as husband and wife. This pronouncement gives any religion or sect the freedom or latitude in conducting its respective marital rights, subject only to the requirements of the law. So meaning there is no prescribed form of religious ceremony. So what the petitioner conducted was a marriage ceremony because the minimum requirements set by law were complied with, while the petitioner may view this only as a blessing. The presence of the requirements of the law constitutive of the marriage ceremony qualified this blessing into a marriage ceremony. Article 9 marriage license. Okay, what is a marriage license? A marriage license is issued by the LCR of the city or municipality where either the contracting party habitually resides. So you just don't go to any LCR and get a marriage license. It should be in the city or municipality where you are a habitual resident. Okay? What are the exceptions to the marriage license requirement? Okay, those marriages which are at the point of death, those marriages in which the parties reside in remote places, because it is very difficult to go to the LCR in order to secure a marriage license. Marriages between people who previously cohabited for at least 5 years. So, because what is required only for those who cohabited for 5 years or more is only an affidavit of cohabitation. Okay, and for religious ratification of a valid marriage. So if you are already married in civil rights, there is no more need when you go to church again for religious ratification to get a marriage license. Okay? Now, the license shall be valid in any part of the Philippines for a period of 120 days from the date of its issuance. So you must remember that when you already have a marriage license, the place of marriage is no longer in issue. You don't need to get married in the place where you got your marriage license. So what is important is that you get your marriage license in the place where you are a habitual resident. Now you can marry anywhere in the Philippines. If you want to go to Boracay, you can do so. If you want to go to Siargao or to Dapitan or any other places in the Philippines, your marriage license shall be valid there, okay? Provided that it is within the period of its validity, which is 120 days from its issue. We now go to the case of Co versus Republic. So we have this case involves a situation wherein the marriage license was secured after or was issued after the marriage took place. Can it be done? Meaning, can the marriage license be on a quote unquote to follow basis? The Supreme Court said no, it cannot be done. Okay, why? Because a marriage license is the consent of the state to the marriage. You have to have it first. It was the one who will plot the solemnizing officer with authority to solemnize the marriage. So the Supreme Court said this case, Article 58 of the Civil Code makes explicit that no marriage shall be solemnized without a license first being issued by the LCR, the municipality, or either party habitually resides. A marriage performed without a corresponding marriage license is void, this being nothing more than the legitimate consequence flowing from the fact that the license is the essence of the marriage contract. It is the authority granted by the state to the contracting parties after the proper government official has inquired into their capacity to contract marriage. The requirement and issuance of a marriage license is the state's demonstration of its involvement and participation in every marriage, in the maintenance of which the general public is interested. As the marriage license, an essential requisite, actually it's a formal requisite, is clearly absent, the marriage of petitioner and respondent. Okay, we have another case involving marriage license. Actually, there are a lot of cases. Okay, second to nullity of marriages under Article 36 is the cases involving marriage license. These are the very popular grounds for securing a nullity of marriage. Okay. So in this case, Lobel discovered that their marriage license indicated in the certificate of marriage had been issued not to them but for another couple. Okay, so In this case, a valid marriage license is an indispensable requirement to the validity of the party's marriage, since it is the marriage license that grants the solemnizing officer the authority to solemnize the marriage. For a marriage to be considered void due to lack of marriage license, the lack of license must be apparent on the marriage contract, or at the very least supported by certification from the LCR that there was no such marriage license issued to the party. So if you become lawyer someday and your ground for securing nullity of marriage is the lack of marriage license, so you just present the local civil registrar to attest or to testify that there was indeed no such marriage license that was issued, or if they do exist, that it was not issued to the parties but to another couple. Okay? Dayot versus Dayot. So this case refers to an affidavit of marital cohabitation. If there was a false statement in the affidavit of marital cohabitation, remember that when you have been living together as husband and wife without the benefit of marriage for 5 years or more, and you have no impediment to marry each other, okay, you can already dispense with the marriage license requirement. You can go directly to your priest or to the judge and then execute an affidavit of cohabitation, okay, and then you can get married. There is no more need for the issuance of a marriage license. So the issue in this case is whether the falsity of an affidavit of cohabitation, because they have fallen short of the 5-year requirement, rendered the marriage void ab initio for lack of marriage license. The Supreme Court said the minimum requisite of 5 years is an indispensability card in the language of the law for a marriage celebrated under Article 76 to be valid. This material fact cannot be dispensed with. So, if, for example, you have lived together only for 4 years and 9 months, okay, and then you have a word in your affidavit that you have lived for more than 5 years, that would not be considered as compliant with the requirements of the law, and that would not dispense with your need to secure a valid marriage license. Without a valid marriage license, that marriage would be considered as void. The solemnization of a marriage without prior license is a clear violation of the law and would lead off or could be used for the perpetration of fraud. Okay. To permit a false affidavit to take the place of a marriage license is to allow a circumvention of the law. If this court is to protect the fabric of the institution of marriage, we must be wary of deceptive schemes that violate the legal measures set forth in the law. Okay, Cabrera versus Cabrera is almost similar to the previous case of Dayot versus Dayot. Whether petitioner and respondent had cohabited as husband and wife prior to the marriage so as to constitute an exception to the requirement of marriage license. So the minimum requisite of 5 years is again indispensable. The falsity of an allegation relating to the period of cohabitation, it is not a mere irregularity, but it refers to the quintessential fact that the law precisely required to be deposed and attested to by the parties. Both petitioner and respondent lied before the solemnizing officer and misrepresented that they had cohabited for at least 5 years. The parties are not exempt from the marriage license requirement, thus rendering their marriage void ab initio. Okay. Now we go to Article 21. Article 21 speaks of certificate of legal capacity to contract marriage. Okay. Before we discuss Article 21, it is important to remind you of the nationality principle. You must remember that in the nationality principle, laws relating to the legal capacity, to the condition, status, legal capacity of persons, they are governed by the national law of that person. So with respect to foreigners, their legal capacity to enter into marriage is governed by their national law. Okay, so Article 21 tells us that when either or both of the contracting parties are citizens of another country and they are getting married here in the Philippines, it will be necessary for them, before a marriage license can be obtained, to submit a certificate of legal capacity to contract marriage issued by their respective diplomatic or consular officials. So there is a certificate of legal capacity to contract marriage. Okay? It is not sufficient that a mere affidavit is submitted. It must be a certificate of legal capacity to contract marriage issued by their diplomatic or consular official. So if, for example, an American national is getting married to a Filipino here in the Philippines, the American national will go to his embassy or consular office and secure a certificate of legal capacity to contract marriage. Okay. Can what if the American merely executes an affidavit that he is capacitated to enter into marriage? Can that suffice? The answer is no. Why? Because he is an American, he is not a stateless person. An affidavit will be sufficient if the one who is executing it is a stateless person. Because a stateless person, he does not have any embassy or consular office to go to, precisely because he has no state. The second paragraph tells us, stateless persons or refugees from other countries shall, in lieu of the certificate of legal capacity, submit an affidavit stating the circumstances showing such capacity to contract marriage. Okay? Uh, the marriage certificate is the best evidence of your status as a married person. Okay? It is the proof of the existence of a marriage. Okay? There are several jurisprudence on the proof of marriage. The best proof of relationship is the marriage certificate. In the absence thereof, however, the court can receive oral evidence of the fact of marriage. Now we go to Article 26. Okay. Article 26, the first paragraph tells us, all marriages solemnized outside the Philippines in accordance with the laws in force in that country where they were solemnized are valid, and valid there as such, shall also be valid here in the Philippines, except those prohibited under Article 35, 1, 4, 5, 6, 36, 37, and 38. Okay, so all marriages, okay, which are solemnized outside the Philippines, meaning abroad, okay, regardless of nationality, if they are valid in the country in which they were solemnized, they are also valid here, except those which are prohibited under Articles 35, 1, 4, 5, 6, 36, 37, and 38. What are those? Under Article 35, 1. Okay, those which are marriages entered into by minors. So meaning if the foreigner, okay, and two foreigners, for example, in their in the country where they are national, if, for example, marriages between 16 years old is valid in their country and it was solemnized there, will it be recognized as valid also in the Philippines? The answer is no. Why? Because they are prohibited under Article 35, paragraph 1. Okay? Under Article 36, you know what is under Article 36, psychological incapacity. Under Article 37, incestuous marriages. Under Article 38, those marriages which are void by reason of public policy. So these marriages, although valid in the country in which they were solemnized and valid in accordance with the national law of the country where these people who got married are nationals, they are not considered valid in the eyes of Philippine law. Okay? Let us now go to the second part. When a marriage between a Filipino citizen and a foreigner is validly celebrated, and a divorce is thereafter validly obtained abroad by the alien spouse capacitating him to remarry, the Filipino spouse shall likewise have the capacity to remarry under Filipino law. Of course, you all know that we have no divorce in the Philippines. We are the only country who has no divorce. Okay, so if, for example, there is a marriage between Filipino and a foreigner, and the foreigner has already obtained a divorce of the said marriage abroad, okay, the Filipino, considering that he is bound by his nationality, cannot, okay, be considered as divorced with his foreigner husband. Why? Because the Filipino, being governed by his or her national law, has no divorce. So what the family code did is merely to extend a recognition of that divorce which was obtained abroad. Okay? So as for the Filipino spouse to enjoy also its benefits. Okay? So it is in fact a recognition of the effects of divorce. Okay? So what are the requirements for recognition of foreign divorce? First, there was a valid marriage celebrated between a Filipino and a foreigner. The divorce was then validly obtained abroad by either or both parties. The divorce capacitated the alien spouse to remarry. Okay? The Filipino spouse shall likewise have the capacity to remarry under Philippine laws, provided that the divorce obtained abroad is recognized through a petition filed for the purpose. And the divorce obtained abroad must be proved as a fact. Okay? The divorce as well as the loss of the country of the foreigner which capacitated him to remarry must be proved as a fact. We have also a lot of cases on Article 26, beginning with Republic versus Manalo. So in this case, this is an interpretation of paragraph 2 of Article 26. Okay. So paragraph 2 of Article 26 requires that the divorce must be obtained abroad by the foreign spouse. What if it is the Filipino spouse or who obtained the divorce? Or what if it is jointly obtained by both spouses? Okay? Can that divorce which was obtained jointly by the spouses be granted recognition under Philippine laws? Okay, the Supreme Court said paragraph 2 of Article 26 confers jurisdiction on Philippine courts to extend the effect of a foreign divorce decree to a Filipino spouse without undergoing trial to determine the validity of the dissolution of the marriage. It authorizes our courts to adopt the effect of foreign divorce decree precisely because the Philippines does not allow divorce. Our jurisdiction recognizes a valid divorce obtained by a spouse of foreign nationality, but the legal effects thereof on custody, care, and support of children must still be determined by our courts. So the idea of the amendment is to avoid the absurd situation of a Filipino as still being married to his alien spouse, although the latter is no longer married to the former because he has obtained a divorce abroad. So the reason behind the law was employed by the Supreme Court in the case of Manalo. Because the primary reason for the inclusion of the second paragraph of Articles 26 is to equalize the situation with respect to the Philippines. Because the foreign spouse has already been freed from the bonds of the marriage and is no longer tied to the Philippine spouse. So the same effect should be given to the Filipino spouse by recognizing the divorce and allowing the Filipino spouse the opportunity to remarry and be freed from the marital bond. So Manalo pleads for the recognition and enforcement of the divorce decree rendered by the Japanese court. Uh, when this court recognized a foreign divorce decree that was initiated and obtained by the Philippine spouse and extended its legal effects on the issues of child custody, it should not stop short in likewise acknowledging that one of the usual and necessary consequences of divorce is the right to remarry. Um, it only requires that there be a divorce validly obtained abroad. The letter of the law does not demand that the alien spouse should be the one who initiated the proceeding wherein the divorce decree was granted. It does not distinguish whether the Filipino spouse is the petitioner or the respondent in the foreign divorce proceeding. The court will not follow the letter of the statute. When to do so would depart from the intent of Congress or would otherwise yield conclusions inconsistent with the general purpose of the act. A Filipino who initiated a foreign divorce proceeding is in the same place and in a like circumstance as a Filipino who is at the receiving end of an alien initiated proceeding. Therefore, the subject provision should not make a distinction. It is extended as a means to recognize the residual effect of the foreign divorce decree on Filipinos whose marital ties to their alien spouses are severed by operation of the latter's national law. Okay, Racho versus Panaka is on all fours with Republic versus Manalo. Again, this concerns the interpretation of paragraph 2 of Article 26. The Supreme Court again reiterated that the national law of Japan does not prohibit the Filipino spouse from initiating or participating in divorce proceedings. It would be inherently unjust for a Filipino woman to be prohibited by her own national laws from something that a foreign law may allow. The prohibition on Filipinos from participating in divorce proceedings will not be protecting our own nationals. To rule that the foreign spouse may remarry while the Filipino may not only contributes to patriarchy. This interpretation encourages unequal partnerships and perpetuates abuse in intimate relationships. A foreign divorce may be recognized in this jurisdiction as long as it is validly obtained regardless of who among the spouses initiated the divorce process. Okay, Abel versus Rule. Also, it's again a reiteration of Racho, Tanaka, and Manalo cases. Okay, in this case, there was a joint filing of divorce. Okay, whether a divorce jointly obtained by a Filipino and her alien spouse can be judicially recognized in the Philippines. It is immaterial who initiated the divorce proceedings. In Manalo, once a divorce decree is issued, the foreign spouse is deemed to have obtained a divorce which capacitates him to remarry. The same status should therefore be afforded the Filipino spouse. Again, we have the case of Morana versus Republic, which is similar to Abel. Again, it is a divorce which was jointly applied for by the parties. A foreign divorce decree may be recognized in the Philippines, although it was the Filipino spouse who has obtained the same. Based on a clear and plain reading of the provision, it only requires that there is a divorce validly obtained abroad. The letter of the law does not demand that the alien spouse should be the one who initiated the proceeding where the divorce was granted. The court will not again follow the letter of the law because to do so would depart from the true intent of law. Okay, then again, there is an OCA circular. Okay, because regarding the proof of foreign laws, it is very difficult to obtain a translation of the foreign laws under which the divorce was obtained. So the Supreme Court in OCA Circular number 157/2022A made a compilation of several foreign laws on marriage and divorce so that to make it easier on the part of the parties who are seeking recognition of several divorce decrees or divorce judgments. So instead of going through the difficult process of obtaining a certified copy of the laws of their foreign spouse on marriage and divorce, the Supreme Court compiled the laws of foreign countries on marriage and divorce. So all the judge has to do is to click the link and the certified true copy of the laws of foreign countries on marriage and divorce will be obtained. Okay, we have the case of Sakai versus Republic. Again, it refers to Article 26. Okay, what remains to be proven is the pertinent Japanese law on divorce. Considering that Japanese laws on persons and family relations is not considered as a judicial notice, but because of that OCA circular, it can be considered as judicial. Then we have the case of Galapon versus Republic. This case is personally known to me because I am the one who decided this case. So this is a case involving a Filipina who married a Korean national. Okay, however, after a few years of their marriage, their relationship turned sour. So they obtained a divorce in Korea. Now, Galapon came to my court seeking for a recognition of the divorce decree that was obtained in Korea. Now, I granted the recognition. At that time, when I decided that Republic versus Manalo was not yet promulgated by the court. So I just relied on the equality because the family code or the Congress cannot have enacted that provision if it is not for the purpose of benefiting the Filipinos. So the issue in the case of Galapon is whether the Court of Appeals erred in denying the recognition of the divorce. Because it was appealed, the Office of the Solicitor General, even though I granted and recognized the divorce decree, the Solicitor General questioned it, elevated it on appeal to the state. So it reversed my decision. Now, when it went to the Supreme Court reinstated my decision and said that the letter of the law does not demand that the alien spouse should be the one who initiated the proceeding wherein the divorce decree was granted. Does not distinguish whether the Filipino is the petitioner or the respondent in a foreign divorce proceedings. Laws have ends to achieve and statutes should be construed as not to defeat but to carry out such ends and purpose. Applying a verba legis or strictly literal interpretation of a statute may render it meaningless and lead to inconvenience, an absurd situation, or injustice. To obviate this aberration and bearing in mind the principle that the intent or the spirit of the law is the law itself, resort should be to the rule that the spirit of the law controls its letter. The provision is a corrective measure to address an anomaly where the Filipino is tied to the marriage while the foreign spouse is free to marry. Whether the Filipino initiated the foreign divorce or not, a favorable decree dissolving the marriage bond and capacitating his spouse to remarry will have the same result. The Filipino will effectively be without a husband or a wife. A Filipino who initiated a foreign divorce is in the same place and in a like circumstance as a Filipino who is at the receiving end of an alien initiated proceeding. Okay? Now, what are the marriages which are exempt from the license required? Again, in cases either or both of the contracting parties are at the point of death. Of course, if you're at the point of death, you don't have time to secure a license. That is the reason why they are exempt. Number two, under Article 28, if the residence of either party is so located that there is no means of transportation to enable such party to appear personally before the LCO. So, in cases, for example, where the parties are living in the mountains where it is a very remote location and you have to cross several rivers and mountains to go to the nearest local civil registrar. Okay? Article 31, a marriage in articulum mortis between passengers or crew members may also be solemnized by a ship captain or by an airplane pilot, not only while the ship is at sea or the plane is in flight, but also during stopovers at ports of call. Okay? And Article 32, another in articulum mortis provision, a military commander of a unit who is a commissioned officer shall likewise have authority to solemnize marriages in articulum mortis between persons within the zone of a military operation, whether members of the armed forces or civil. Okay? Another exemption from marriage license, marriages among Muslims or among members of ethnic cultural communities may be performed validly without the necessity of a marriage license, provided that they are solemnized in accordance with their customs, rights, or practices. Okay? And the last exemption, no license shall be necessary for the marriage of a man and a woman who have lived together as husband and wife for at least 5 years and without any legal impediment to marry each other. Okay? What is a marriage in articulum mortis? A marriage in articulum mortis is when either or both parties are at the point of death, provided that they are still conscious of what they are doing. Okay? What if after the marriage, the party who is dying managed to survive? Is the marriage still valid? Of course, yes. Okay. But you must remember that either of the party must be at the point of death for it to be valid. Okay. Can solemnizing officers, regular solemnizing officers like judges or religious officials or governors, mayors, solemnize a marriage articulum mortis? The answer is yes, of course. Okay, if they can solemnize regular marriages, they can also solemnize marriages in articulum mortis. Okay, but for a marriage in articulum mortis to be valid, one of the parties has to be at the point of death. Okay, now what if they are not in the point of death, such as but it was solemnized as if it was in the point of death? The marriage will now become void. Why? Because of the absence of a marriage license. Okay? Because the only thing that exempts a marriage in articulum mortis from the marriage license requirement is the fact that it was made at the point of death. Okay? A soldier who is about to go to war, before he went to war, married, for example, his fiancée, it will not qualify as an in articulum mortis. The soldier has to be wounded, at least, at the very least. a wound that is fatal enough so as to cause his death. Okay, in other words, parang frustrated na ang dating. Okay, it has to have at least a wound. Okay, for it to qualify as one at the point of death. Okay. Ratification of marital cohabitation. Okay, what is the reason why is it that they're exempt from the marriage license requirement? Okay, it is to discourage such persons because the publicity attending the marriage license may discourage these persons from legalizing their status. It is to facilitate the legalization of the youth. Okay, we have the case of Salgado versus Salgado. So in this case, Luis filed a complaint against the spouses Salgado, seeking the annulment of a deed of sale as well as deed of settlement of estate of the deceased Severina. Luis in his complaint said that he is the surviving spouse of the late Severina. They were married in a civil ceremony. Luis claimed that because of the preceding acts, he was divested of his share in the conjugal properties and of his inheritance as a compulsory heir of Severina. Now, Joanne countered that she was unaware of any marriage contracted by her mother with Luis. She knew, however, that Luis and Severina had a common law relationship. Okay, now, Luis gave his testimony and presented several documentary evidence, which included a marriage contract. Now, the spouses Salgado disputed the validity of the marriage on the ground of lack of marriage license. Now, the RTC rendered that decision in favor of Luis, holding that the marriage was valid. It noted that the marriage contract, being a public document, enjoys the presumption of regularity. Now, the issue is whether the absence of a marriage license may be proven on the basis of a marriage contract, which states that no marriage license was exhibited to the solemnizing officer on account of the marriage being of an exceptional character. So, an examination of the marriage contract reveals that there was no marriage license number. It appears that no marriage license was exhibited to the solemnizing officer. So consequently, the entries made in Luis and Severina's marriage contract proved that there was no marriage license. However, it is clear that Luis and Severina were not married to each other prior to the civil ceremony. So the only date of marriage appearing on the records. So being the ceremony held was the only marriage ceremony between the parties, and this was not solemnized pursuant to any ratifying religious rite, practice, or regulation, but a civil one. It is evident that this marriage does not fall under the purview of exceptional marriages. There is no prior ceremony to ratify. Thus, this marriage is not of an exceptional character, and a marriage license is required for the marriage to valid. However, instead of proving that a marriage license was issued to them, Luis relied mainly on the presumption of the validity of the marriage. This presumption, however, does not hold water. If there was a marriage license issued to Luis and Severina, its absence on the marriage contract was not explained at all. To be considered void on the ground of absence of a marriage license, the law requires that the absence of the marriage license must be apparent on the marriage contract, or at the very least, supported by certification from the local civil registry. The court cannot turn a blind eye to the statements made in the marriage contract because these refer to the absence of a formal reference. The party should not be afforded any excuse to not comply with every single requirement of the marriage. Okay, we now go to the case of Republic versus Lázaro. Again, this refers to the absence of marriage license because it was not issued by the LCR of Cavite and it was not among the marriage licenses recorded in the said office. A certification issued by the civil registrar enjoyed probative value as his duty was to maintain records of data relative to the issuance of marriage licenses. So Jacqueline Adu's marriage license purportedly issued by the Las Piñas as evidence. Strikingly, however, it was a mere photocopy, okay, and not certified by the proper officer. As she failed to present her mother the certification of the LCR of Imus, attesting that no application for marriage license was made by the parties, enjoys at most probative. Then we go to the case of De Castro versus De Castro. Okay, in this case, the parties met and became stars. They planned to get married, so they applied for a marriage license. However, when the couple went back to the LCR, the marriage license already expired. In order to push through with their plan to get married, they executed an affidavit stating that they have been living together as husband and wife for at least 5 years, and the couple got married. However, the affidavit that they executed in lieu of the marriage license contained a false narration of facts because they have never lived together as husband and wife. Now, the issue is whether the trial court had a jurisdiction to determine the validity of the marriage between the petitioner and the respondent in an action for support. So this is an action for support, not an action, not a direct action to declare the marriage null and void. Okay. Reiterating Ninyal, the court said that the court may pass upon the validity of a marriage even in a suit not directly filed for the purpose, so long as it is essential to the determination of the case. It is clear from the evidence that the parties did not have a marriage license when they contracted their marriage. Instead, they presented an affidavit stating that they had been living together for more than 5 years. However, respondent admitted the falsity of the affidavit when she was asked. The falsity of the affidavit cannot be considered as a mere irregularity in the formal requisites of marriage. The law dispenses with a marriage license requirement for a man and a woman who have lived together and exclusively with each other as husband and wife for a continuous and unbroken period of at least 5 years before the marriage. The aim of this provision is to avoid exposing the parties to humiliation, shame, and embarrassment concomitant with the scandalous cohabitation of persons outside a valid marriage due to the publication of every applicant's claim for marriage license. The false affidavit, which petitioner and respondent executed so they could push through with the marriage, has no value. It is a mere scrap of paper. They were not exempt from the marriage license requirement, and failure to do so rendered the marriage void and breach. Okay? So we have the last case, Linyal versus Badayo. Okay. The issue in this case, may the heirs of a deceased person file a petition for the declaration of nullity of his marriage after his death. Okay? Remember, in the case of De Castro, we have an action for support. So it is an indirect action. In the case of Ninyal, okay, it is not the parties to the marriage but the heirs of a deceased person. Can he file a petition to declare the marriage as null and void even after the death of the party to the marriage? So after their father's death, petitioners filed a petition for nullity of marriage, alleging that the marriage was void for lack of marriage license. In this case was filed that the validity or invalidity of the second marriage would affect his successional rights. Okay? Now, of course, Norma moved to dismiss on the ground that they have no cause of action because they are not among the persons who can file an action for annulment of marriage. The court ruled that the second marriage involved in this case is not covered by the exception to the requirement of a marriage license. Therefore, it is void ab initio. So from the time that Pepito's first marriage was dissolved to the time that the respondent to the time of his death is only about 20 months. So even assuming that Pepito and his first wife were separated in fact, and thereafter both Pepito and respondent started living together, that has lasted for 5 years, the fact remains that their 5-year period cohabitation was not the cohabitation contemplated by law. It should be in the nature of a perfect union that is valid under the law but rendered imperfect only by the absence of the marriage contract. So the subsistence of the marriage, even when there was an actual severance of the filial relationship, cannot make any cohabitation with any third party as being one of husband and wife. The 5-year common law cohabitation, which is counted back from the date of the celebration of the marriage, should be a period of legal union. Had it not been for the absence of marriage, this 5-year cohabitation should be the years immediately before the day of the marriage, and it should be a period of cohabitation characterized by exclusivity, meaning no third party was involved at any time within the 5 years and continuity that is unbroken. So if one of the parties, even though you have lived together for more than 5 years, if one of the parties had an impediment during the said 5-year period, then that is not the 5-year common law cohabitation period that is contemplated under the law. The 5-year cohabitation period must be characterized by exclusivity, meaning you have lived together with that person for a continuous period of 5 years and you have no legal impediment to marry, to enter into marriage with that person. So Pepito had a subsisting marriage at the time when he started cohabiting with the respondent. It is immaterial that when they lived with each other, Pepito had already been separated, in fact, from his spouse. The subsistence of the marriage, even when there was actual severance of the filial companionship between the spouses, cannot make any cohabitation by either spouse with any third party as being one as husband and wife. Void marriages can be questioned even after the death of either party, but voidable marriages can be assailed only during the lifetime and of the parties. So that is all for the day. Thank you for listening.